Namaste India. Very happy Independence Day to all my viewers. Today on this occasion, Advocate Club, that is my channel as a legal channel, bring you a unique celebration that blend legal knowledge with patriotic favors. And also, I welcome you to in this special episode for the ultimate legal destination. Today's episode is about the understanding of our right and responsibilities as a citizen. Constitution of India. The preamble of the Constitution was adopted by the Constituent Assembly. And in Ribaribari case, it says that preamble is not a part of the India, but it is only key to open the minds of the makers. And in the Golaknath case versus State of Punjab, Subba Rao Justice itself mentioned that preamble is content nutshell its idea at its inspiration. Next one case law is very important for the part of constitution, that is a Keshwananda Bharati. We all know Keshwananda Bharati is a basic structural doctrine, and it is mentioned that preamble is the part of the India and therefore it can be amended, but in subject to basic structure. Originally, Constitution was India was handwritten by Prem Behari Narayan Raizada, and its italic style written in the italic style with a beautiful calligraphy and decorated by artists from Shanti Niketan. Indian Constitution written in Hindi and English in both language. First of all, the Indian Constitution is written by this Prem Beharia sir. And originally, when our constitution is drafted, it contains 22 parts and 395 articles with 9 schedules. Thereafter, it can be amended by lots of amendments, and now it is 26 part, 443 plus articles and 12 schedules right on. And it is the longest constitution of the world, and we are having sovereign country. The Constituent Assembly, which first met on 19 December 1964 for to preciously making this constitution, totally the time taking for this 2 year 11 month and 18 days to come up with the final draft of this constitution by our constitutional academy committee. And when the draft was prepared and put to debate and discussion, over 2000 amendments were made before it was finalized. So after lots of amendments, our constitutional draft is final, and after finalize our constitutional draft, drafting committee of constitution was finally completed this draft on 26 November 1949. We are also called this 24 November 1949 as a date of adoption and constitutional celebrated as a constitutional day, but it was legally enforced only after 2 months on 26 January 1950, which come to known as a Republic Day. It is a date of commencement. The handwritten constitution was signed on 24th January 1950 by 284 members of the Constituent Assembly, which included 15 women. So, the Constitution Assembly signed before 2 days of the commencement of our Constitution, that is the 24th January 1950, by Constituent Assembly members of 284, which having 15 women also. So Indian Constitution is also called as a bag of borrowing. It is specifically says by the author, that a historian, that is a patchwork. Though it is a patchwork, it is a beautiful patchwork. The concept of 5-year plan was taken from USSR, in short from Russia. We have taken lots of things from other constitution, therefore it is called as a borrowing bag. So we have starting to know from whom we are taking what part of our constitution. So directive principle of state policy, which is taken from Ireland, and fundamental right we have taken from USA. So cause structural part of our constitution is borrowed from the Government of India Act 1935. The parliamentary form of the government we have taken from the United Kingdom. The mother of democracy, as parliament is a supreme and they have non-written constitution. Emergency provision we have taken from Germany, and the amendment provision we have get amendment provisions from South Africa. And also lots of things we have borrowed from another countries. So therefore it is called bag of borrowing. Although it is a patchwork, it is a beautiful patchwork, and we have proud to our constitution. The idea of liberty, equity, fraternity is from France. So next is basically by starting the Constitution of India recognize 9 fundamental rights for us as a basic human right for all its citizens. But thereafter Supreme Court making lots of judgments to give human being lots of fundamental rights, we can see after. Inserting in the beginning right to property was also known as a fundamental right. Firstly, right of property is also a fundamental right, but after the amendment of the 44th Amendment 1947, it was deleted. It mentioned under Article 31. In 62 years of its adoption, lots of time it is amended, like 100 plus time it is amended, as now our constitution has undergone total 105 amendment is concluded. So socially secular, in our preamble we have seen we the people of India. Who adopted the preamble? We the people of India. We adopted this preamble to ourselves, to having solemnly resolved to constitute India into what? India into sovereign, socialist, secular, democratic republic, and to secure all its citizens. So the words socialist and secular startingly not available in our preamble, but thereafter by the amendment of 42nd Amendment, which also called as a mini constitution, amended these two words as a socialist and secular in our preamble. Before amendment we have 3 rights: sovereign, democratic and republic. But after 42nd Amendment of 1976, socialist and secular word is added to our Constitution of India. And now we have seen the 5 words which is important as examination point of view too. Equality for all religion and social and economic equality by socialist. In the case of S.R. Bommai versus Union of India, held that secularism is a basic feature of our Indian constitution. Right now UCC is a very hot topic for making a change of our citizens. So secularism is our basic structure specifically mentioned in S.R. Bommai case, and basic structure theory given under the Keshwananda Bharati case law, and it is a 13 judges bench. So firstly, you cannot amend basic structure. You can amend the constitution but subject to basic structure. and UCC, it means secularism, is our basic feature. So kind of difficulty arising at the time of enacted the UCC or enumerated the UCC, and UCC also as our directive principle. So we can start our fundamental right one liner to understand what is fundamental right of our citizens. Fundamental right were taken from America, as we have already seen. Part 3rd of the Indian Constitution deal with fundamental right. Originally, we have 7 fundamental rights like right to equality, right to freedom, right against exploitation, a right of freedom of religion, cultural and educational right, right to property, and a right to constitutional remedy, Article 32. And right to property is deleted now by 44th Amendment, as we have already seen. 14th Amendment. Okay, and now constitutionally protected right of property. Right of property now not is a fundamental right, but it is a constitutional right as on, and now it is inserted into Article 301. Right to equality, it is our first fundamental right which given under Article 14 to 18. Article 14, 15, 16 article collectively includes general principle of equality before law. Equality before law and equal protection of law. So there are multiple cases about Article 14. It says that about equality before law and equal protection of law to the general peoples. And before Article 14, it is having Article 12 to 35 deal with fundamental right, part 3rd of the Indian Constitution. Article 12 is stated about the definition or meaning of the state, and state includes parliament, central government, state legislature, state government, local authority, and any other authority. Any other authority is a wider term. Under this, we can say lots of authority added by the Supreme Court in various judgments like Ajay Hasia versus Khalid Mujib. The government of Engineering College is included as a state by the Supreme Court. Next case law is Ramanand Dayaram Shetty versus International Airport Authority of India. In this case, Supreme Court held that International Airport Authority is also a state. And very special thing, friends, we need to know, judiciary is a state or not. This question arising before Supreme Court, and Supreme Court decided that in the Premchand Garg versus Commissioner of Excise case law, it held that when judiciary work as administrative function, then it is an state. Administrative, we have no space, so we can write here administrative. When judiciary work as a administrative work, then it is also state. Judiciary is also called as a state. But when judiciary work as a judicial function, like judgments dictated, so when judiciary work as judicial function, it is not an state. It mentioned in Premchand Garg versus Commissioner of Excise. Next case law for regarding the concept of state is a Zee Telefilm Limited versus BCCI. BCCI it is a cricket body and BCCI is not a state. So in MCQ or any multiple choice question or any competitive examination, you have a question framed by the examiner as a what is a state and giving 4 options like BCCI, judiciary, and engineering college. You opt what is not a state. So what is not a state is a BCCI. Like this question frame in our examination, every competitive examination. So I mentioned specifically here, that is Article 12. Thereafter Article 13. mentioned as a doctrine of judicial review. It is in the case of Marbury versus Medicine inserted the Supreme Court of USA Justice Marshall is incorporated this doctrine as a doctrine of judicial review. So, law having ordinary law and a constitutional amendment law. It is a battle between the judiciary and executive. We have no that much time to understand depth of the concept, so we can start it as only one liner. Article 13 barely says pre-constitutional law violates fundamental right is void. Post-constitutional law violates fundamental right, that is part 3rd of our constitution, is void. That's it. The Article 13 specifically mention void pre or post both of constitutional amendment or enactment which violates fundamental rights. And Article 13 specifically in clause 3rd giving definition of law. By multiple case laws, the Supreme Court says that what is the law. So, if time permits, we can discuss in detail. Now we have seen Article 14. Article 14 is a wider concept and it is specifically mentioned right to equality. State shall not deny to any person. Here is a any person mentioned in Article 14. Any person means legal or natural, both persons. Both persons. Equality before law and equal protection law. The Article 14 is class legislation is prohibited by the Article 14 and reasonable classification is accepted by the Article 14. Essential of Article 14 is a state, second is a person legal and natural person. In legal person, company, corporate and associations are also a legal entity. It available to citizen and non-citizen, to both of us. We have seen the fundamental right. At that time we need to know which fundamental right is available to whom. Some fundamental rights are available to only citizen and some are both of citizens. So, legal person, non-citizen, citizen, equality before law, equal protection law, and that in this Article 14 prohibits class legislation and permits reasonable classification. In Article 14 also lots of judgments like Maneka Gandhi, Shreya Singhal, Saira Bano, Joseph Shine, which is a section 497 of IPC struck down by the Supreme Court as a adultery in Joseph Shine case on the ground of Article 14, and dance bar case, like multiple cases. So thereafter Article 15 its prohibition of discrimination on the ground of religion, race, caste, sex or place of birth in education advancement. So it is a narrower concept than Article 14. Thereafter it is also having amendment in the Article 15, and in last Article 15 clause 5 added into our constitution by the amendment of 93rd amendment 2005 known. Okay, then thereafter Article 16 it is also a deal to equal opportunity in the matter of public employment. So it deals with public employment matter. It is having also lots of amendment and inserted various sub clauses into Article 16 after Indra Sahani judgments and M. Nagarajan versus and General Singh, and also the case laws relating to Article 16. Thereafter Article 17 and 18 dealing with the journey promotes the philosophy of social equality. What kind of social equality? Article 17 deals with abolition of untouchability. So untouchability is prohibited and it is offense or in under our constitution, and it is for protection to this untouchability. The bill passed by the parliament as the name under the protection of civil right bill of 1955. In the article 18 we have seen abolition of title. Article 18 says that except military or academic destination, we have all extra titles abolished by our constitution. So that is basic parameter of untouchability. Okay, abolition of title. That is basic parameter of article 14 to 18 deal with equality. Thereafter we have seen a right to freedom. It's mentioning under article 19 to 21. First one is a fundamental right, and under article 19 we have seen every citizen shall have fundamental right. What kind of fundamental right? Right of freedom. While dealing with protection certain right regarding freedom of speech, all citizens shall have rights. First one is a speech and expression. Next, assemble peacefully without arm. Okay, here is and not or. So you assemble peacefully and without arm, not or. Remember this point also, friends. Next one is associate or union or cooperative society, and the cooperative society is inserted by the 97th amendment 2001. Then move freely throughout territory of India. You can move freely. This is our rights, friend, citizens. Next one is the right is settled in any part of the territory, and it was inserted by 44th amendment. Settle it any part of India. And next one is F, which is deleted. Okay, that is F, which is deleted, and that is G, deleted by 44th amendment. 44th amendment F clause, which is dealing with right of property. We have already seen right of property is deleted by the amendment of 44th and 1978. So next one is a 19G, right to carry on any trade, profession, occupation or business is also a fundamental right. That both are rights, our fundamental right, subject to what? Subject to reasonable restriction. Reasonable restriction for all this fundamental right. The first one is a special speech and expression. It is also having some reasonable restriction. You have right to speech or express yourself by any word making it, but for some subjective reasonable restriction, and that subjective reasonable restriction is sovereignty and integrity of India. Second one is security of India. Security of India. Third one is friendly relation with foreign state. Next, public order, morality and decency. Fifth one is incitement of offense. Sixth is contempt of court. Contempt of court. Okay, and last one is a defamation. Defamation, that is 7 reasonable restriction to our first fundamental right, that is speech and expression. Next one is the 7 or more than reasonable restriction given to only speech and expression. Thereafter we have seen BCD, lots of fundamental right given. This 7-6 fundamental right is also a reasonable restriction, but that not much. For the second fundamental right, assemble peaceful without arm, the reasonable restriction is only 2. First one is a sovereign and next one is a public order. So first sovereignty and integrity, and next one is a public order. Thereafter we have seen the 19C right to associate and cooperative society. It is also having some of reasonable restriction. First one is sovereignty, integrity of India, next public order, and third one is a morality. That's it. Then we have seen E, its deal with reside, move truly throughout India, right to move freely throughout India, and the reasonable restriction that to right to reside and settle any part of territory India. Reasonable restriction is only general public and the interest of scheduled tribes. Next rise is the right of property which is deleted, and thereafter the right to carry on any trade, profession and occupation. It is also a reasonable restriction subject to return in a business, profession and carry any trade, occupation or business. The only one reasonable restriction is a qualification. You need to carry any business, you can, but only qualification is a reasonable restriction. That's it for Article 19. Article 20 deal with protection in respect of conviction of for offences. It having three parts or three subclause into Article 20. First one is a no ex post facto legislation, and next one is it means no retrospective effect to the criminal law. 1, 2 and 3. And second one is a no double jeopardy. It means no person shall be punished and prosecuted for the same offense more than once. And the third one is a no self incrimination. It means no person shall be compelled to be witnessed against himself, and it is mentioning in the case law of Sylvia versus State of Karnataka. In the case, Supreme Court held that modern investigation techniques like narco analysis, okay, we have no place so we can rub it. In Sylvia case, we have discussed Article 20. In Sylvia case, the Supreme Court held that what is narco analysis, brain mapping and lie detector tests are unconstitutional, so it is not taken by without the permission of the accused person. And taking signature, thumb impression, handwriting, blood sample is not violates Article 20, so it is permitted. Article 21, while dealing with protection of life and personal liberty, it is having no person shall be deprived of his right to life and personal liberty except procedure established by law. So no person deprive his right. How? Without the procedure established by law. And who can establish procedure for this act, amendment, anything done in the constitution or for the fundamental right? The parliament having right to enact any law, but law is a reasonable law, and it is parliament having right given under Article 35 to make any law. But what kind of law? It is just and reasonable law mentioned in the case of Maneka Gandhi. And thereafter the Article 21A deals with right to education. Right to education is inserted by the amendment of 86 in 2002. There have three educational amendment into our Indian Constitution. First one is 21A, compulsory education all children the age of 6 to 14, and next one is a duty, and DPSP also mention right to education. So same amendment 86 amendment of 2002 is dealing with the educational right for fundamental right, direct to principle of state policy and fundamental duties. 51A article subclause K. Article 22 deals with protection against arrest and detention in certain cases. So Article 22 comprise two parts. First part is Article 22 is otherwise person arrested or detained under a law otherwise than a preventive detention law. Clause 4 to 7 are applicable to person arrested or detained under the preventive law. First right is after detention or arrested person is to right to consult legal practitioner. Second right is right to communicate ground of arrest to the accused person and right to produce before magistrate within 24 hours. It is our fundamental right, friends, to the produce to the accused person within 24 hours to the nearest magistrate. And provided that it is not applicable, Article 22 is not applicable to alien enemy and person arrested under the Preventive Detention Act. That two are exceptions to the Article 22. Maximum period for preventive detention and is given under Article 22 3 months. It is also make a question. Preventive Detention Act maximum period is 3 months for detention. Next one is right against exploitation. Right against exploitation dealing with Article 23 and 24. It is prohibition of trafficking in human being and forced labor. So prohibit slavery, not only slavery, also trafficking in women and children. It is mentioned in the case of People's Union versus Union of India. Human being, begging, other similar form of forced labor prohibited by this article. Then Article 41 dealing with no children below age of 14 years of age shall be employed in any factory, mine or hazardous process. Prohibit employment of children below the age of 14 years. So it is also punishable, and child labor is punishable. We also know that it is making an act by Parliament, that is Prohibition and Regulation Act of 1986 enacted by the Parliament. Next one is right to freedom of religion enumerated under Article 25 to 28. Article 25 mentions that subject to public order, morality, health and other provision of Part 3rd we have seen. Part 3rd is a fundamental right. So other part 3rd of this constitution, every person shall have right to practice, profess and propagate religion of his own choice. So 3P here under in Article 25. Practice, propagate and professes. Profession हो गया friends. Professes. And right to propagate. Does not comprise right to convert. Conversion is not propagation. Okay. Next one is Article 26 of the Constitution dealing with freedom to manage religion affair. Manage religion affair, not amend or make. So the constitutional amendment given the right to manage affairs of the management, establishment and administer religion institution, manage its own affair in the matter of religion, acquire movable property and immovable property. That is also right given under this Article 26 to the religious body. Article 27 dealing with freedom as to payment of tax for promotion of any religion. So no one can compel any person to pay a tax for promotion of religion. Article 21 deal with freedom as to attendance at religion instruction and religion worship in certain educational institution. No religious structure shall be given any educational institution which is wholly maintained out of the state fund. So you cannot compel to make like any religious worship in any institution, educational institution. Next one is the cultural and educational right, which deals with Article 29 to 30. Article 29 dealing with protection of interest of minority. Any section of citizen, here is a only citizen. It is the article for only citizen, not a both citizen or non-citizen. Any section of citizen of India residing in any part of the Indian territory having distinct language, culture or script. The three words mentioned in that, culture and script, shall have right to conserve the same. So you have any language, any culture or any script, all religions having a right to conserve the same. Like Jallikattu case, Belgada race, bull cart, these all are examples to protect their interest of minority. Next one is Article 30. Article 30 deals with every religious or linguistic minority shall have right to establish and administer educational institution. Article 30 inserted by the Amendment of 44 1986 and its omit. Now it is inserted under Article 13A, right to property. We have seen already. Only thrice article remain, friends. Continue with me and bear the patience to know our constitution on this Independence Day. So saving of certain laws 31 to 1 to D inserted by 42nd Amendment and lots of repealed by 43rd Amendment. Right to constitutional remedy. So one of the basic and fundamental right is given by our constitutional committee to us, like a fundamental right remedy. We have having lots of fundamental rights. If state infringe our fundamental right, then we have some remedy to revenge or to back our fundamental right. There is a no right without remedy. So the remedy, where you go to take remedy, you can go in the Supreme Court by the article of 32, making the read to know the remedy of your right. Where there is a right, there is a remedy. Ubi jus ibi remedium. The Latin maxim mention this term. Dr. Babasaheb Ambedkar says that the heart and soul of the Constitution, the Article 32 is a heart and soul of the Constitution, is mentioned by the Dr. Babasaheb Ambedkar, and Article 32 giving certain writs to approach Supreme Court if any person, citizen or non-citizen, infringe their fundamental rights. So 5 writs given under Article 32 to approach the Supreme Court for infringing their fundamental rights. First one is habeas corpus, to have the body. Mandamus, we command. Prohibition, to prohibit. To lower judiciary, to not make a proceeding. Quo warranto means show your authority, under what authority you are doing. And last one is and certiorari, the quashing of lower judiciary orders by the higher courts. That is a 5 writs where we can reach to the Supreme Court for infringement of our fundamental right. And as on High Court also having writ jurisdiction under Article 226. High Court is higher jurisdiction as on Supreme Court, because Supreme Court having only right after infringing your fundamental right, after infringe your fundamental right, then you can move to the Supreme Court. But any other right other than fundamental right infringed by state, then you can move to the High Court. So High Court is a Honorable High Court is a more wider jurisdiction than Supreme Court. But if Parliament given right under Article 139 to the Supreme Court, the same power of the High Court is under the Supreme Court also, making any fundamental right or other law infringed by a state, they can entertain the matter by the Parliament in Article 139. Court can take suo motu when the basis of public interest litigation. It is a PIL. Article 33 is a power of the Parliament to modify right confirmed by this part to its application to the member of armed force. So, for the member of armed force, Article 33 mentioned that member of armed force right can be member of armed force right can be take off or the fundamental right not to give some of the fundamental right not given to them for protection of our country. Okay, that's it. And Article 34 is dealing with power of the Parliament to restrict right confirmed by this part during marshalling law. So when is a martial law, there also it is an exception for fundamental right. And Article 35, as we have deal our last fundamental right, Article 35 dealing with Parliament has only power to enact the law. So Parliament only have right to enact the law, not the state legislature. Enact the law, not the state legislature. Like under fundamental right, we have seen Article 16.3, Article 17, Untouchability Prohibits Act, enacted by Parliament. Article 33, Article 23.3, Article 34, like that, all act enacted by the Parliament. So Parliament having right to make any enactment for the fundamental right infringing by state, but not to the state legislature. State legislature having no power to make law. That's it for today, friends. We have seen total fundamental rights, which is very important in our constitution. In next lecture, we have seen directive principle of state policy, which is a DPSP under Article 32 to 51. Have a nice day, friends. Thanks for watching. Please subscribe to my channel, like and share. If anything else you want, you can comment to improvement of my channel.